Are you undocumented and you have a US citizen child with serious medical issues? In this video, I want to talk about two possible ways that you may be able to stay lawfully in the United States if your child has severe medical problems that require you to be here to take care of them and to make sure that they're getting the medical attention that they need. My name is Ashley, and I'm an immigration attorney. I have nearly 13 years of experience in immigration law. In this video, I'm going to focus on the situation where an undocumented parent is wondering how they can qualify to receive a work permit so that they can stay in the United States in order to care for their very sick US citizen child who needs them in the United States. So there are two main ways to go about this. The first option is applying for medical deferred action. This is a very, very nuanced, specific case type where an undocumented parent essentially comes forward and presents themselves to immigration to request the ability to stay lawfully in the United States based on the fact that their US citizen child has severe medical problems that require ongoing care in the United States. So this means that the undocumented parent needs to provide very compelling evidence of their child's condition or conditions that require them to be receiving medical care in the United States. And they need to be able to show that there is nobody else here who can be helping the child to make sure that they're getting the care that they need. This is an affirmative application with immigration, which again is why I say it requires the parent to come forward essentially out of the shadows of being undocumented to present themselves and their situation to immigration to ask for that permission, which is called deferred action. Deferred action is not actually a lawful status if it is granted. All it means is that immigration has looked at your case and they have decided that at this time they are not going to try and deport this parent from the United States. They're not going to take any kind of enforcement action. They see why they've come forward and they are deciding, typically it's for a period of 2 years at a time, to give them deferred action, which basically means they are saying, we know you are here unlawfully in the United States and you have demonstrated why you need to be here, even though you're here unlawfully. And so we are not going to take any action against you at this time to try and remove you from the United States. Once somebody receives medical deferred action, they then become eligible for a work permit, which is why this option can be so beneficial to a parent who may qualify. So you would get your work permit. Typically, it's issued for up to 2 years, but that can change depending on the case. Every case is different. The point to know is that it is possible to apply for a work permit if you are granted deferred action by immigration. The second option for a parent who has a child with severe medical problems is that they have to wait until they are actually put into deportation proceedings. So this means that the parent is somehow caught by immigration. They are discovered by immigration to be unlawfully in the United States. And then they are put into removal proceedings or deportation proceedings, which means that they have to start going to immigration court hearings and they have to go before an immigration judge. There is a case type in this situation called cancellation of removal. One of the requirements for cancellation of removal is having a US citizen child who is under the age of 21 who would suffer extreme and unusual hardship if you as the parent were not allowed to stay in the United States. There are other requirements for cancellation of removal as well that I'm not going to go into in this video. The purpose of this video is just to briefly explain that this is another potential option for a parent who has a very sick US citizen child. Now, if you are put in deportation proceedings and you qualify for cancellation of removal, this is another way that if you win your case, you receive a green card and you are allowed to stay in the country legally with your green card based on the hardship that you demonstrated that your US citizen child would experience if you were not allowed to stay here in the United States. The other thing to know about this case type cancellation of removal is that while this immigration court case is processing, which often can take several years, is that you as the undocumented parent are going to be receiving a work permit during that time, which is also life-changing, which means that you're going to have more stability to provide for your US citizen child while your immigration court case is proceeding up until the final decision from an immigration judge about whether or not you are going to receive your green card. I hope this video has been helpful to you. If you have any questions about your case based on your US citizen child who has medical issues, don't hesitate to reach out to us at 760-812-3778. And don't forget to like and subscribe to my channel so that you don't miss out on future videos on different topics in immigration law.